That's true. Good morning, and welcome to the Public Safety Committee. We have some housekeeping on the consent calendar. We have a bill by Ms. Mitchell. It's item number 4 for anyone who is here for that item. It will be on the consent calendar, and we'll vote on it when we have a quorum.
Thank you, sir.
Okay. And my sign-up sheet. And so we have Mr. Dickinson, bright and early, AB 1435, item number 2. Welcome. Okay. And Mr. Dickinson, if you would indulge the chair, we just got a quorum, so if we could have a roll call, please.
Amiano.
Here.
Knight. Here. Cedillo. Hagman. Here. Mitchell. Here. Skinner. Vacancy.
Okay, and take a motion on the consent calendar. Someone will move.
So moved.
So moved. Second.
Second.
Okay, and roll call, please.
Amiano.
Aye.
Amiano. Aye. Knight.
Aye.
Knight. Aye. Cedillo. Hagman.
Aye.
Hagman. Aye. Mitchell.
Aye.
Mitchell. Aye. Skinner. Vacancy.
All right. The consent calendar is out. Mr. Dickinson.
Good morning, Mr. Chairman. Thank you very much. I'm here to present this morning AB 1435, which clearly defines that athletic coaches, administrators, and directors are mandated reporters of child sexual abuse and neglect, and requires, and I want to underscore because this is really the focus of this particular bill, that these individuals receive training in the identification and reporting of sexual abuse. And at the outset, let me say there's an author's amendment that's been suggested, which I will take. And I think that is a reasonable suggestion that's been made under the circumstances. With respect to this larger issue, this is not just a matter of a few high-profile cases, which we have seen in the headlines and on our televisions at major universities around the country, but it's something that often occurs in many of our own districts, in fact. In the last 6 months, approximately, there have been at least a half dozen accounts of improper contact between coaches and young people in the Sacramento region alone. Unfortunately, we're hearing about these types of incidents with increasing frequency. Now, speaking as a former student athlete myself for many years through high school and college, I find this particular problem deeply troubling because I know firsthand that young athletes can develop a relationship with a coach, which in fact can supersede the relationship that young person may have even with their parents, let alone other adults. It's, I think, instructive that after the Penn State scandal broke, the late Joe Paterno was quoted as saying, "I didn't know exactly how to handle it and was afraid to do something." And that really gets to the core of what this bill is about. It's to make sure that those who are in positions of coaching and athletic administration know what they're hearing about or know what's being reported to them or they see and know what to do about it. AB 1435 addresses this particular problem by building on California's existing mandated Reporter Act. In fact, in reviewing it after the most high-profile incidents we saw last fall, I discovered that there is no certain inclusion in the Act of athletic coaches, administrators, and directors. In fact, if they're not certificated teachers, they may not be covered, and many coaches aren't. Many coaches aren't coaching in schools. They're coaching in youth organizations and other endeavors. We, in this legislation, make sure that those who should have training get it, or that volunteers who are often involved are encouraged to get the training they should. I also want to just make a quick comment on what the cost might be, although this is not where we're going to talk about cost, I understand it. But it is, again, I think, instructive. Our own California Department of Social Services offers free online training for mandated reporters. And I know that there are many other providers of that kind of training. So I believe this is a straightforward bill, and it would improve our mandated reporter legislation. Thank you, Mr. Chairman.
Thank you, Ms. Dickinson. And any witnesses in support?
Yes, I'm Connie Valentine from California Protective Parents Association. I'm in full support of this bill and urge your aye vote on it. We know that strangers commit only about 10% of child sexual abuse, and that molesters are mostly well known to their victims. They're found everywhere. They're found wherever children are, in homes and churches, daycare, foster care, scouting, particularly schools. And as we know, they move into positions of trust, they groom their victims, and then they sexually abuse them. Athletic coaches are sort of an apex of this circle of trust. This month, actually, in Yolo County, there are two, just this month, there are two athletic coaches who are being prosecuted. As we saw in the Sandusky case, the vulnerable children were brought into his circle of trust through his organization, but most predators don't have that efficient a method, a feeder system to their prey. They all know how to get close to them. Although we all know about the suffering of sexually abused children, it's not quite as well known that the after effects in adulthood last forever. The Centers for Disease Control and Prevention and Kaiser Permanente have shown through this gigantic 18,000-person study that the after effects include substance abuse, depression, suicide, and oddly, cancer and heart disease from the various methods of behavior that people have.
We'll need you to conclude.
Absolutely. In 1997, we made clergy-mandated reporters. It really helped the situation. We urge your aye vote on this one.
Thank you very
so
much, ma'am.
Thank you. Good morning, Mr. Chair and members. Dawn Kapke, McHugh Kapke and Associates on behalf of Crime Victims United of California and the Child Abuse Prevention Center, both in strong support. We think this makes sense. These people, these coaches, these athletic personnel have contact with some of our most vulnerable persons in our populations, and we think that it only makes sense for them to be required to be a mandated reporter, particularly when these young, vulnerable people are in a position that could be compromised. So with that, we support this bill strongly. Thank you.
Thank you very much. Any other witnesses in support? Any in opposition? All right, seeing none, members, do we have any questions? Moved, seconded. Mr. Dickinson, would you like to close briefly?
I would ask respectfully for your aye vote. Thank you, Mr. Chairman.
Thank you very much. Mr. Dickinson, we had a very sophisticated discussion about this issue, and I really appreciated your sensitivity. You know, one thing, because this is such a visceral issue, and of course, given the media exposure of incidences such as this, you know, we do have a number of bills now that will deal with this area. And, you know, my caveat is, again, this is so visceral, and I think it's incumbent on us as lawmakers to take a step back. It's a little difficult if you're a parent yourself, or, you know, when you read the graphic details. It's very, very upsetting to me as well. But we also have to be very careful about hysteria. You know, as a gay man myself, that misperception of being a predator, we are eroding that fast, but there's always a little bit of that in and around this issue. And I really do applaud you for your, you know, ability to parse and see the issue for what it is, and as well as some of our colleagues. So that has a reassuring effect on me, because nobody wants to defend something that is so egregious and many times systemic, which I think is one of the things you're pointing out. So I appreciate your witnesses, and I've recommended an aye vote. And if we could have a roll call, please.
Amiano?
Aye.
Amiano, aye. Knight? Knight, aye. Cedillo? Hagman? Hagman, I. Mitchell. Mitchell, I. Skinner. Vacancy. Bill's out.
All right, the bill is out.
Thank you, Mr. Chairman.
Okay, thank you. Now we have Mr. Mendoza, item number 5, AB 1462. Good morning.
Morning. Thank you, Mr. Chair. Members, I'm here to present AB 1462. Mr. Chair, members, before I start, I would like to ask for an authored amendment to the bill and ask that the minimum mandatory fines currently in the bill be removed. AB 1462 helps correct an oversight in the law as it applies to crimes of vehicular manslaughter by seeking greater equity in how work credits are applied to sentencing. The reason I am compelled to bring this issue to you today has to do with seeing one of my staffers in my district office go through some heartbreaking experiences of losing his sister-in-law as a result of a drunk driver driving on the opposite side of the road, killing her and her boyfriend upon impact. We later come to learn that the offender would be serving less time for his crime than if he would have just caused this young couple what is legally termed great bodily injury. The need for this bill became obvious. Currently, individuals who drive under the influence of drugs and alcohol can actually serve less time if they kill someone than if their victim is injured and survives. You ask, how could this be? A driver under the influence who kills his or her victim is typically charged with vehicular manslaughter. Through this charge, though this charge is considered a serious felony, current code entitled the defendant to 50% work credit, meaning that if the driver is sentenced to 4 years, he or she would actually serve just 2. On the other hand, if this same driver were to inflict great bodily injury on the victim, he or she would be charged with a felony driving under the influence with an enhancement charge for the infliction of great bodily injury. Under current statute, the addition of great bodily injury makes the crime a violent felony, therefore limiting the work credits applied to his or her sentence to only 15%, meaning that in this scenario, our driver will serve 85% of his sentence as opposed to 50%, where the victim actually dies. AB 1462 addresses this gross disparity and seeks greater equity by asking there be a straight 15% limit on work credits in the cases where vehicular manslaughter results in death and not just those with great bodily injury. With me today to expand on this discussion and to answer any questions, Ms. Susan Price, Senior Deputy District Attorney for Orange County.
Thank you. Good morning. Thank you, sir. Good morning, Mr. Chair and members of the committee. My name is Susan Price. I work for the Orange County District Attorney's Office. For the last several years, I've had the opportunity to work specifically on fighting in court on DUI death cases. Those are cases where a driver who's driving under the influence of alcohol or drugs will get in a collision where someone will be killed. One of the things that I've found is that the victims of these crimes, who are usually ordinary people whose lives have been affected by this very tragic offense, are shocked to hear that if you get in a collision driving under the influence of alcohol or drugs and you injure someone, you're only eligible for 15% conduct credit. Whereas if you're driving under the influence and you kill someone, if you injure them, it's 15% conduct credit. That's what you're eligible for. If you kill them, you're eligible for 50% conduct credit. It's simply a loophole in the law, and that's all it is. And that's how we explain it to the victims of these crimes. Victims of these crimes in every jurisdiction, including every jurisdiction included in this courtroom, in this hearing room where each of you serve, are constantly surprised to hear that these types of cases are eligible for 50% conduct credit, such that a person who drives under the influence and kills serves less time in their sentence than if they were to injure. This is a loophole that's created within the current existing law. What's important to clear up this inequity, because it simply doesn't make sense. It doesn't make sense that you would serve less time if you killed someone than if you injured them. This particular conduct credit calculation in fixing the inequity in it would not at all affect realignment, which I know has been a major aspect of your agenda and the agenda of the Assembly. And the reason is that because these particular crimes are exempt from the realignment scheme. In terms of the fiscal impact, the amount of impact to the prison population is actually very small. It would affect 0.4% of the incoming prison population because these crimes, vehicular manslaughters, are very few and they don't impact a huge number of prison attendants. Yeah. Absolutely. We believe that fixing this inequity would make sense and it would satisfy the huge loophole that's in the system right now and allow victims of these types of crimes to have some justice and some fairness in these cases. I thank you for your time.
Thank you very much. Next witness, please.
John Lovell with the California Police Chiefs Association and the California Narcotic Officers Association. We'd incorporate by reference the excellent testimony of the first witness.
Thank you. Any other witnesses in support?
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. I just echo the comments of my colleague from Orange County.
Okay. And any other?
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California District Attorneys Association in support.
Okay. And are there any witnesses in opposition? Please approach.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California DUI Lawyers Association, also on behalf of the California Attorneys for Criminal Justice. I'm also joined by Steve Reese, who's one of our legal experts, so he'll be testifying. But let me just make a couple of comments before I turn it over to him for the second. He'll be the second witness in your time constraints. The first is I think there's a little bit of confusion in terms of how this bill has been presented. The underlying offense is a DUI with injury and a DUI with death. Both have 50% credits right now under current law. And for a death case, you will get a longer sentence than an injury case for the underlying offenses. So let's be clear. In fact, for a gross vehicular manslaughter, you can get up to 10 years in state prison. Okay, so let's be clear. They're not disproportionate. There's no loophole. That's how it should be. Where it gets a little bit confusing is when there's this great bodily injury enhancement that is not specific to DUI offenses. It is a GBI enhancement that applies across criminal law. And Steve Reese will talk about that in just a second. When you apply that, there is a potential for a very small number of cases.
The felony, is that?
Yes, that would be a felony, a strike felony. Okay, I'm sorry, the felony for the gross vehicular manslaughter. Yeah, that was a 10-year. That's a 10-year felony. So let's be clear. You will get a longer sentence on the underlying offense if the person dies versus if there's an injury in most cases for the equivalent case. So that's a little bit of confusion in terms of how it's been described. Where I get the GBI enhancement, I'm going to turn it over to Steve Reese to explain how the GBI enhancement works. And that's where the 85% credit comes into play and the strike comes into play. So we're talking about two totally different things. But if Mr. Reese can go ahead and take over.
Good morning, Mr. Chairman.
Good morning.
Ladies and gentlemen. My name is Stephen Reese. I'm here on behalf of California Attorneys for Criminal Justice. I think the error here potentially is the focus being on the result rather than the conduct, and also that there is being put out there the idea that somehow you do less time, or the defendant does less time as a result of a death of a victim rather than injury. And the reality is that is not the case. As Ignacio says, in a gross vehicular manslaughter, when gross meaning gross negligence, not an intent, but gross negligence, the sentencing range is 4 years to up to 10 years. 4 years as a minimum is more than what someone would get in a DUI with injury where there is not great bodily injury. Now, great bodily injury is an enhancement that came into effect in, I think, the 80s or late 70s in California to increase the punishment when someone, let's say in an assault, in a fight, or a sexual assault, was injured beyond what would be the expected degree of injury. For example, in a battery, you hit someone, there's a reason to believe there's going to be some injury. But if you hit that person and they are the proverbial glass jaw plaintiff and they suffer severe injury, or what we call in the law great bodily, GBI, then that's when the 3-year enhancement comes in. Now, the vehicular manslaughter statute assumes, and correctly so, that you have got a deceased person. That's why there is no enhancement on top of the actual crime itself. The crime itself recognizes that another human being has been killed as a result of the defendant's conduct. I think if the committee stays focused on the conduct rather than the result, the law is not as disparate or unequal as the proponents of the bill would have you believe. If you solely look at the GBI, then it may appear so. But what really needs to focus here is that it's the conduct. And the example I would give you, just very quickly, you have a mother driving home the child from a playgroup, and she unfortunately has been drinking with her friends before. She's a .08. She gets blinded momentarily by the sun in her eyes, gets in an accident, the baby dies. That's vehicular manslaughter. She could go to prison, and most likely would. But do you want that result all the time and say, well, she should get a greater punishment than someone who commits a deliberate, intentional assault? I don't think so.
And just a point of clarification, the author's amendment does deal with the fines, but currently, as I understand it, not exactly what you're talking about. Correct.
We could talk about that if you want, but that's not.
No, I think we've done fine.
Okay.
Let me take any other witnesses in opposition and then open it up to the committee members.
Thank you. Jim Lindberg on behalf of the Friends Committee on Legislation of California in opposition. Given the fact that we're under a federal court order to reduce prison population, given the deep cuts that are being made to the state's safety net, we think we should be very skeptical about legislation that incrementally increases upward pressure on the prison population. Okay. We're also concerned that we've become so punitive that there are very few positive incentives for correctional administrators to promote good behavior in prisons.
Very much.
Thank you.
Thank you. Next speaker in opposition.
Libby Sanchez on behalf of the California Public Defenders Association. We appreciate the author's amendments but continue to be gravely concerned about the credit issue in the bill.
Thank you. Any other witnesses in opposition? Seeing none, Mr. Knight and Mr. Hagman.
I just want to get some clarification here. We're talking about the credit. I'm talking to the district attorney from Orange County. So if I give you a scenario of I get a 4-year sentence and someone else gets a 10-year sentence, but that 10-year sentence gets a credit that brings them down to only a 6-year sentence.
It would bring them down to a 5-year sentence under the current scheme.
Okay, but that's what we're talking about, right? We're talking about credit.
That's correct.
Once they've been assigned their prison assignment there, they've been convicted, that's what we're talking about, correct?
Yes, sir. And originally our bill with Assemblymember Mendoza's office was more, it included a proposed increase in the initial sentence. But we did have an opportunity to speak with Mr. Pagan, and as a result of that, we've pared down the bill so that it only addresses credits. That's really the only issue here, and that's really the heart of this bill. The fines, all that is really not the heart of this bill. The heart of this bill is credits, and that's all we're talking about. So once they're already sentenced.
So just the crux of it, if you if you get convicted of a manslaughter and someone did die, your credits could be better than if you don't.
That's correct. And just to use an example based on something that's
not the sentence, not the longer term, not the 10 years to 4 years, not any of that, but your credits could be at a higher percentage
That's correct. So if you are in a DUI collision and someone dies, the maximum sentence that you could get is 10 years. But you would only serve 50% of that time, so you'd only serve 5 years. But if you're driving under the influence and you injure someone such that, let's say they get a broken leg, that would qualify as great bodily injury. Your maximum exposure is 6 years at 85%. So you're only eligible for 15% conduct credit at the 6 years. Whereas if you kill someone, your maximum exposure is 10 years at 50%.
Okay. Thank you, Mr. Knight. Mr. Hagman, did you want to respond to Mr. Knight as well? Go ahead. And then Mr. Hagman.
Yeah, through the chair. Thank you, Mr. Chair. Just for clarification, in that scenario, notwithstanding the credit difference, you still would spend more time if, in the manslaughter case, in custody than you would, because you have 50% of 10 is 5 years.
Okay.
85% of 4 is 3.
But the bill
It's
is talking
6
about
years.
credits, correct?
He said
Correct.
4. Under his
No.
scenario, he said 4.
All right, it's a math question. We'll deal with it later. Stephen Hawkins, we don't need. All right, go ahead, sir. All right, the bill has been moved. Is there a second? Mr. Mendoza, would you like to close briefly?
And for the sake of time, instead of me closing, I'll let Ms. Price finish, just in case there were some outstanding questions that were brought up.
Sure. And if you could be brief, that would be.
Thank you. Members of the committee, I appreciate you, and thank you for taking the time and giving us your patience today. This bill would correct something that impacts victims of these kinds of cases every day. You can't understand the impact that these cases have on people until you're talking to a family member who's lost their son, their daughter, their precious cargo that they carry in their cars every single day as a result of an impaired driver. This bill makes sense, and it helps explain to these people that although they'll never get closure, there is some sense of justice in this system, that it makes sense. And I thank you for your courtesy.
Thank you very much. Mr. Mendoza, I really thank you for presenting this bill. And there are areas in it that I am very uncomfortable with, not through any motivation or intent of yours. As I mentioned on the previous subject, when we hear about terrible accidents and losses without closure, it's not that we're unfeeling and don't want solutions, but it's also, again, incumbent on us to take a step back, look at the bigger context of it and the morality of it. And I just feel that while I appreciate the amendment in and around the fines, that this is, and I know there's a gap, that exists in the credit schemes, but I do think extending sentences is not the way that I would prefer to address this. And so I am going to recommend a no. I'd be happy to work with you on this in another form, or if you want reconsideration. But I would like to have a roll call now with the recommendation of no.
Amiano?
No.
Amiano, no. Knight? Aye. Knight, aye. Cedillo? Cedillo, no. Hagman? Aye. Hagman, aye. Mitchell? Mitchell not voting. Skinner? Vacancy. It's on call.
It's on call. It needs to. Thank you, Mr. Mendoza. Mr. Fuhrer, I think you're up at bat.
Good morning, Mr. Chair, colleagues. I'm here to present AB 1434. At the outset, I would like to take the amendment recommended in the committee analysis, and let me proceed very briefly to discuss the bill. As the committee is aware, each year thousands of kids, minors, are on college campuses for a variety of reasons. Under current law, however, the lion's share of employees at colleges and universities in California are not mandated reporters. This bill addresses that gap in law, and the need for the bill was made evident in the Penn State situation when janitors, maintenance workers, administrators, others were cognizant of the acts that were alleged to have taken place there and yet did not report, were not mandated to report. There are some instances in which moral obligation alone is simply not enough. And again, with the acceptance of the amendment recommended in the analysis, I would urge an aye vote by members of the committee. Thank you.
Thank you, sir. Witnesses in support. We usually have 2 witnesses, 2 minutes.
Yes, my name is Doug Johnson. I'm with the California Alliance of Child and Family Services. We're a statewide association of approximately 120 private nonprofit agencies serving children and families. Today, I'm also speaking on behalf of the California Advocacy Institute. Mr. Chair, members, we all know that college campuses routinely invite minors onto their facilities through a variety of special academic and athletic programs. I know my own stepson attended one at Sacramento State University several years ago. Mandatory reporting has long applied to those who work at places where minors are housed or otherwise spend many hours of their time. Teachers, child care providers, youth program administrators, primary school teachers and administrators, and other employees have all long been subject to mandatory reporting. Just as those folks have been subject to mandatory reporting, we think it only makes sense that college and university employees should be under the same obligation when those minors move into those settings. Most of my members have, again, long been subject to mandatory reporting, and we think this is a common sense addition to the law. Thank you for your consideration.
Thank you. Next witness.
I would just add Don Kepke, McHugh Kepke and Associates on behalf of Crime Victims United of California and the Child Abuse Prevention Center, also in support for the exact reasons already stated. Thank you.
Connie Valentine, I urge your aye vote on this bill.
Thank you so much.
John Lovell on behalf of the California Police Chiefs Association and the California Narcotic Officers Association in support.
Any other witnesses in support? Any witnesses in opposition?
Libby Sanchez on behalf of the California Public Defenders Association. We have been in communication with the author's office to bring one continued concern we have to his attention and look forward to having further conversations with him. And that has to do with situations where you have a law school or attorneys who are working at an institution of higher education who are bound by their attorney-client privilege responsibilities. And we want to make sure that the bill as written doesn't conflict with that and put attorneys in a situation where they would have to make the choice between violating the law and maintaining their, sacrosanct, we believe sacrosanct, responsibility to keep the communications between themselves and their clients privileged. For those reasons, we continue to oppose, but look forward to having ongoing conversations about this.
I would imagine that that's an endemic issue, isn't it? Not just applying. We'll let Mr. Fewer deal with that. Okay. Any, Mr. Hagman?
Thank you. I'll move the bill, Mr. Chair, but I just have a question since you brought up, we've seen three bills, or we're seeing three bills this morning on an incident that was kind of brought up by the news in Penn State. Right here in our backyard, we have many incidents on the high school level, including Miramonte, the grade school levels. You brought up the fact that teachers have this. I'm not familiar with the law. Does all the school employees, all the K-12 employees have that same thing? I'm just surprised we're not addressing some of that. It seems like more of a systemic issue here on those levels, and maybe it is already covered. I was just curious if either one of our experts knew on that.
Yeah. I believe it to be the case that all employees at K through 12 are mandated reporters, as it is now. There may be other ways to address the Miramonte issues. They're not before us at this moment.
There's a second? Okay, Mr.
I want to address questions around
and Mr. Cedillo?
Or attorney-client
privilege. Yeah. No, I'm happy to continue to work with the public defenders on that issue. There's got to be a narrow way to address that question, including, saying that nothing in the bill is construed to amend the attorney-client privilege. There are lots of ways we can work on this, I think.
Okay. All right. And any other comments or questions? Mr. Knight.
Just a quick comment. I want to clarify this. This is only on the premises of the institution. Is that correct?
Or university-sponsored events. That's the committee analysis recommends having the bill pertain to university-sponsored events, whether they be on campus or off campus. Correct, Mr. Chair? Yes.
Okay, so if they're at a camp and there was a bus ride to some other event that they were sponsoring, then that would be covered.
As long as the university is sponsoring it, correct.
All right, Mr. Fewer, the bill's been moved and seconded. Would you like to close?
I urge an aye vote.
Okay, and this, as Mr. Hagman referred to, this bill is one of a few that we'll be hearing around this issue, and I think that while most higher education institutions don't interact with children, there are times when this happens, and I am recommending an aye vote. So if we have a roll call, please.
Amiano?
Aye.
Amiano, aye. Knight? Knight, aye. Cedillo? Cedillo, aye. Hagman? Hagman, aye. Mitchell? Mitchell, aye. Skinner? Skinner, aye. Vacancy. The bill's out.
Thank you, colleagues. Thank you,
Bill
Mr.
is out.
Chair.
Thank you very much. Mr. Bradford.
Thank you, Mr. Chair and members. Existing state law, well, I'm presenting AB 1438, which is a Reporting Sex Crimes Act bill. Existing law states that any witness of a murder, rape, or any forcible act of arousal with a child of age 14 must notify law enforcement, and failure to do so is a crime punishable by imprisonment into county jail for a period of 6 months or fine $1,500 or both. This bill primarily intent is existing. The primary intent, I should say, of existing laws to protect children. This bill seeks to ensure further protection of children in a place by requiring all witnesses of non-forcible arousal with a person under the age of 14 to report that incident. Failure to report would just result again in a crime punishable by imprisonment of the county jail for 6 months or fine of $1,500 or both. This is a simple reporting act, just stating that if you witness a crime with a minor 14 and under, that it must be reported, and simply asking for an aye vote.
Thank you, Mr. Bradford. And if we could have witnesses in support, 2 minutes, 2 witnesses.
Mr. Chairman, members, Dan Filizato on behalf of the Los Angeles County District Attorney's Office. Our office became aware of the proposed amendments to AB 1438 late in the process, so we did not get an official position on the bill as proposed to be amended. However, our office has spoken with the author and would like to continue to work with him to see if there's something that can be done to address the problems that the various bills have talked about today.
All right, thank you. Any other witnesses in support? If you would come to the table, please, or no? Any witnesses in opposition, or am I missing the support witnesses? No? All right. Yeah, so this is opposition? Okay.
Connie Valentine, California Protective Parents Association. Although we agree that reports of crime should go to law enforcement, all reports of sexual abuse, child sexual abuse, should go to law enforcement first rather than CPS first. We believe this bill is problematic in that it might lead to malicious reporting by the general public. We've seen that happen in numerous circumstances, particularly in family court. There are often odd reports that are made. It might overwhelm CPS and law enforcement with a crime that puts into the public another crime that would lead to higher imprisonment rates. So we're opposed to this.
All right, thank you.
Mr. Chairman, members, Corey Salzillo on behalf of the California District Attorneys Association. Unfortunately, we're opposed to the bill. Just for historical perspective, we opposed the creation of this statute in the year 2000 when it dealt with the Sharice Iverson case, and we've opposed attempts to amend the bill since then, not just for consistency, but because of the concerns we have with the underlying statute and its expansion. We appreciate that the goal is to increase reporting. We fear, though, that it's going to have the opposite effect, in that it's going to discourage reporting. We are essentially, and this will probably be the first, last, and only time you'll hear this out of my mouth, but we're turning people who shouldn't be criminals into criminals potentially with this bill.
Yeah. Where's my defibrillator?
I gave the disclaimer. Specifically, what the concern is that if we have a witness to a crime or an act, and we're going to use them as a testifying witness in a case, the possibility arises that, well, you're going to have to charge them with a crime or give them immunity if they fail to report. And since there's no timeline in the bill, I mean, it really is effectively the statute of limitations of the underlying misdemeanor. that there's really no guidance. And so essentially you potentially discouraging a person from reporting if they find out of the requirement after the fact, if they fail to report. And then once it gets to a court case, we think sometimes this is going to potentially damage a case that we might have against a person for the underlying either lewd act or murder or rape. Because if we have to give a witness immunity, the defense counsel, if they're worth their salt, will use that against our case, and the jury will only know that the person was granted immunity and not the nature of the agreement. So we'd ask for your no vote.
All right. Any other witnesses in opposition?
Libby Sanchez on behalf of the California Public Defenders Association. We've been in communication with the author's office. We appreciate the amendments he's taken. We still have ongoing concerns that we've communicated to staff. In particular, well, we have the concerns expressed by the DA, and we really appreciate
Hard to get out.
Yeah, I know. I really appreciated his comments. We also have kind of the reverse concern that expanding existing law to include this requirement would create a situation where individuals might report things that they thought were crimes that really shouldn't be included. So for that reason, we've asked for an age differential to address kind of the Romeo and Juliet situation. We look forward to continuing to work with the author on this. Thank you.
All right, thank you. Any questions or statements from the committee? Mr. Hagman.
Thank you, Mr. Chair, and thank you for bringing the subject. But it's like, what goes in my head is, how do you put morality into the law, and then how do you keep the good people away from the bad people and sorting it out? And hopefully public safety investigators and district attorneys can look at those things and have some kind of flexibility. But what you're doing is you have an existing statute right now for injury, and this broadens that just a little bit. It goes back to, you know, what kind of, I think an information campaign to let people know what to watch out for and stuff would be beneficial to have coincides with this, so we're not trying to unintendedly prosecute witnesses that may have a hard time too. So I just want to kind of get some of your comments on that, because I too are torn on that. I want to protect our children at all costs. At the same time, I can see that with trained personnel, because our teachers and others, they have to deal with the children every day because we're instructing them what to look out for. This is goes out to the general public that may or may not have training, and what that may or may not hurt those chances of prosecution. So I just want some more comments on it. Thank you.
Any other comments? I'm sure you'll respond in your close. Do we have a motion?
I'll move the bill.
All right. And do we have a second? All right. Moved and seconded. So would you like to respond in your close?
Thank you, Mr. Chairman, and I understand the concerns that have been raised by committee members as well as those who oppose this bill. And I, too, grapple with the fact of expanding and creating a real gray area of asking folks to go beyond their comfort level. But I think, as we all have seen from the Penn State incident, what was witnessed by that coach was a clear violation of a child that went unreported, which led to additional abuses of children by the coach that perpetrated that act. And I think we as responsible adults can clearly identify that which is inappropriate without being properly trained. I think we would know it if it was our own children and we were witnessing that. So this is what this bill simply tries to do. I understand understanding that one of the opposition witnesses asked as it relates to age difference, and we're working on that between what might be considered consensual act between a 15 and a 13-year-old. We understand that. So we're working with them to address that concern. So I simply ask for I vote.
Thank you, Mr. Bradford. And I'm happy to hear you say that you've been very, very cooperative, and in taking the amendments have relieved some of my questions. You know, the thing is, I don't think a lot of the law as it exists anyway. This is a slight enhancement, you know, based on just not headlines, but real acts that do happen. And it's, as I mentioned, it's a slight enhancement. You know, forced, not forced. If somebody's 10 years old, what does that really mean?
Exactly.
So I am going to recommend an aye vote on this.
Thank you.
Roll call, please.
Amiano.
Aye.
Amiano, aye. Knight. Knight, aye. Cedillo. Cedillo, aye. Hagman? Hagman, aye. Mitchell? Mitchell, aye. Skinner? Skinner, aye. Vacancy. The bill's out.
All right, the bill is out. Thank you, Mr.
Thank you, Mr. Chair and committee members.
So we have a little housekeeping. We want to lift the call on
Item 5.
item 5, which is Mr. Mendoza's. The recommendation was no, and we need with 2 votes to get out. Sorry.
Skinner? Skinner not voting. Vacancy.
It's 2-2 right now. So where does that leave us? It's a parliamentarian.
I can vote again.
All right. Well, we're going to announce it fails, and if we're asked for reconsideration, which we did offer earlier in the meeting, we would accept that. All right. Thank you. All right, and we will adjourn now. Thank you.